we'll get right into the complaint. This is, of course, in the 9th District of Florida in Orange County, the Circuit Civil Division, the Central Florida Oversight District versus Walt Disney Park and Resort. It's so fresh off the presses. Look, we've got a filing number, but we don't have a case number yet. So that is something we don't have because this is so freshly filed. But as always, your boy Legal Mindset covering it immediately off the press. So here you go. Here's the complaint for declaratory and injunctive relief. So the plaintiff, Central Florida Tourism Oversight District, the district, alleges in support of its complaint for declaratory and injunctive relief as follows. So we're going to get into some basics. And by the way, this is a 188-page complaint. However, about 30 pages of it are legal argument. The rest is backup. So you're talking the Reedy Creek statute. We're talking about a meets and bounds, like a lengthy legal description of property. So this is about a 30-page complaint. Now, I know there's some others out there like the Legal Schmeagles of the world and their lackeys who are always impressed by the length of a complaint. The length of a complaint doesn't say anything on its own. It's the strength of the legal arguments within. So I'm going to be analyzing this for the strength of the legal arguments. So they start out here in the introduction. For 55 years, Walt Disney Parks and Resorts, its predecessors and affiliates, ran their private government on 25,000 acres in Central Florida. Within its fiefdom, Disney wrote the laws that governed itself and chose whether and how to enforce those laws and set its own tax rate. No other Florida business, large or small, enjoyed those benefits. That is absolutely true. The benefit that Disney had in Florida was unprecedented. No other business ever has had it. And in fact, when other businesses like Universal asked for it, they were denied. So Universal does not have a special district. They don't. They just deal directly with the county. That's how every other business, including theme parks, Legoland, SeaWorld, none of them have these benefits. Just Disney. Why? Because they promised to build a city that they ultimately never built after Walt passed away. There is no question that much good came from the special status the Florida legislature granted Disney. That is true. They did grow rapidly because of that special status back in the day. But over time, Disney uses influence to obtain what may have seemed like permanent exemptions from the democratic checks and balances that apply to all other Florida businesses. And to that effect, by the way, all other Florida governments. For example, like other businesses in Florida, Disney is subject to building and fire codes that are supposed to protect the lives and safety of its employees. But unlike other businesses, Disney did not have to worry about these safety rules would be enforced against it. Yes, that is because Disney-controlled district board would never adopt any mechanism for enforcement of those codes. So they never were going to enforce building codes, fire codes against Disney. Disney could do whatever it wanted because it set its own rules. This is what happens when you self-regulate. Earlier this year, however, the Florida legislature took steps to restore the people's sovereignty and establish an independent board to govern the district, a truly independent board, as it should be. A government should always have an independent board that stands separate from corporate interests. That's quintessential to the definition of government. And I will tell you, as somebody who practiced in this area, and we saw this issue with the villages, when it is simply a corporation using a government as an alter ego, that is something that under the federal tax code, as well as under Florida law, is not an actual government. It's not a real government if it's just an alter ego of a single corporation. That's not what a government is supposed to be. In an effort to stymie Florida's elected representatives, Disney covertly cobbled together a series of 11th hour deals with its soon-to-be replaced puppet government. Disney hoped to tie the hands of the newly independent board and preserve Disney's special status as its own government for at least the next 30 years. That's 30 years because of our Marketable Title Act. After 30 years, those would fall off. I know a lot of people made much to do about the King Charles Clause, but that actually doesn't matter. It's something that's legally irrelevant. It was cute, but really an irrelevant thing. So really, after 30 years, anybody who knows Florida real estate knows it would fall off. That's why I said, look, anybody who's getting bamboozled by this King Charles stuff doesn't know how marketable title works in Florida. After 30 years, that clause is going to fall off, and the covenants are going to be unenforceable unless they're re-upped, which obviously the new board would not do. Those agreements reek of a backroom deal drafted by Disney with the acquiescence of a lawyer who represented both Disney and the district. By the way, that would be John McGowan, who was special counsel for the district and also Disney's chief counsel. Funny how that worked. Set a hearing without proper notice and hustled through a compliant Disney control board that Disney knew would not dwell long on the issue. But perhaps out of haste and arrogance, Disney's deal violated basic principles of Florida constitutional, statutory, and common law. As a result, they are null and void, not even worth the paper they are written on. This is the key here, guys, and what I've been harping on. So the last week, excuse me, I got a cough here, and it is 1 a.m. in Seoul, South Korea, but I'm running through this with you guys because this needs to get out because this is urgent. I have been over the last week pumping out reason after reason after reason after reason after reason why Disney will lose even the federal case. This is just bringing those together, saying, look, they're going to present constitutional, statutory, and common law reasons why the agreements, those development agreements, those 11th hour agreements that were passed are invalid. Mind you, any sort of statutory agreement has to comply with, yes, the statutory law, the Constitution, because it can't violate the Florida Constitution, and the common law, the law that's been passed in the courts as related to those sort of agreements. And because it has to comply with all of those things, and it clearly fails for the reasons that I've mentioned, but we're going to hear again in the complaint, that's why it would be void ab initio. So that's that word void from the start. The new board has already taken action to bring accountability, transparency, and normalize even-handed administration to the government Disney used to run. It has adopted rules governing board conduct, hired an outside financial advisor to ensure financial transparency, and retained new independent outside general counsel who are experienced in local government law, as they should be. You need a specialist. This is what I've been harping on. This is why I was paid the big bucks in Central Florida, because this is a very specific area of law with specific rules. You can't just hire any local yokel to do this. In fact, you can't even hire a lot of big law firms because they don't do Florida local government law. They don't cover special districts. It is very specific. You need to know bond finance. You need to know public law, right? As it relates to the powers of special districts, statutory law, how those are actually applied. This is why you cannot just hire anybody. You need specialists. Unlike Disney's former general counsel, are not also Disney's lawyers. So yes, you need to have independent counsel. And it is extraordinarily unethical to represent a company and also the government that is supposedly independent from that company. That is wildly unethical. The new board has authorized the drafting of fire and building code enforcement provisions, one of the most basic safety protocols that prior Disney Control Board never bothered to require. Basic building and fire. Every building has to comply with this. But Disney wants an exemption from basic safety. Remember that dragon that burned down? Yeah, let's continue here. Also, the board has hired an urban planner to make recommendations to the Florida legislature about strategies to make the district more prosperous for those who live and work in and near it. I think that's very good. I think that there should be some thought to how the district is developed. When the new board took office, it expressed to Disney its desire to work together to achieve a win-win scenario that would protect Disney's economic investment in the district, but at the same time, usher in a new era of accountability, transparency, and cooperation with the district's other occupants and neighbors. Disney would have none of that. Instead, despite the obvious deficiencies in the one-sided deals Disney drafted for its former board members to rubber stamp, Disney continues to insist they were valid and enforceable against the district. The district, therefore, seeks a judicial declaration regarding their invalidity. In fact, that's the whole thing here. Disney insists in their federal complaint that these declarations, that this agreement is valid. It's not. And if it's not, they have no federal case. Once again, this is everything. This is why this state law case is the real case. That case in federal court, that's a joke. This is the case that Disney actually has to fight. This is the one to pay attention to. And I will say this as well. Having been someone who was representing Disney's neighbors, right, whether it was Celebration or Bonnet Creek or wherever else, this is absolutely true. All Disney deals were one-sided. If it wasn't completely in Disney's favor, they didn't want you to come to the table, right? They wanted to do what Disney wanted to do. If you weren't there to listen to Disney and bend the knee to the rat, they weren't having any of it. So obviously this is parties and jurisdiction. Obviously this is a special district, right? The CFTOD is a special district established pursuant to the 67. So they're a legacy of that, right? But they were reauthorized recently. So the district exercises local government authority as authorized by the legislature over approximately 25,000 acres in Orange and Osceola County. So it's multiple counties. Prior to the 27th of 2023, the district was known as Reedy Creek. So this is clear that this is the successor to Reedy Creek. So the CFTOD is the successor to Reedy Creek, but Reedy Creek no longer exists. For ease of reference, this complaint generally uses the term RCID when discussing actions taken by the district prior to February 27th. That's very useful. By the way, that's the common slang. I used RCID as well in all my documents referencing Reedy Creek whenever I did deals with Reedy Creek. So this is the common slang for these guys. This was the date of the governance of the district was statutorily transferred to the new board, including the adoption and execution of the development agreement and the declaration of restrictive covenants at the heart of this declaratory relief. The defendant is a Florida corporation with its principal place of business in Orange County. Disney owns and operates Walt Disney World within the district boundaries. These reasons, guys, because the district and Disney are in Central Florida, makes this the most appropriate venue. Federal court in the Northern District, not appropriate at all whatsoever for this case. This is a quintessential Florida law case. It's about real property. It's about Florida statutes. It's not about the First Amendment. The court has jurisdiction over Disney because of the Florida corporation with its principal place of business. All right, obviously, this is subject matter jurisdiction because it's over 50K. And venue is proper because Disney has an office for transaction of its customary business in Orange County. The action is accrued in Orange County, and the property subject to the development agreement is located in Orange County and a bit of Osceola County. I would add that in there. But either way, that's the Ninth Circuit, so very appropriate. Factual allegations, Disney's control over Reedy Creek. So in 1967, the legislature created Reedy Creek. Disney World owned the majority of land within the boundaries of RCID, and the Florida legislature hoped that creating RCID would assist the Disney company in its plans to develop this area of Central Florida. That was their plan, to use RCID to develop it into a city initially. The plans not only included a theme park along the lines of Disneyland in California, but the construction of a planned community that Walt Disney called the experimental prototype community of tomorrow. Shout out to my good boy, Valiant Renegade, WW Pro, Mexican Iron Man, those boys. We've been talking about this forever. This was all hinged on Epcot, the experiment prototype community of tomorrow, being an actual community, an actual planned community. Walt's true vision was a planned community. He was big into that. The theme park opened in 1971 and was a financial success. However, Disney's plan, especially after he died, never materialized, although Disney co-opted the name for its Epcot theme park. Epcot is a shadow of what Walt wanted it to be. That was supposed to be an actual community, not something where you hire minimum wage workers from around the world, repping different countries. No, that was not what it was supposed to be at all whatsoever. It was supposed to be an actual community. Closer to, if anything, closer to celebration than anything else. Although celebration is a far cry from the dream of Walt, who wanted an actual city where work was done with offices and all that stuff under that oversight. On its face, RCID appeared similar to other special districts periodically established by the Florida legislature. Like other special districts, RCID was authorized to exercise many of the traditional powers of local government, such as regulation of zoning and development, capital improvement, building code enforcement, fire and safety. They also gave RCID the power to levy ad valorem taxes. Very normal, all normal so far. RCID was governed by a 5-member board of supervisors, whose only qualification was that they own at least 1 acre of land within RCID. Election required a majority vote of the electors, who had to vote at least 1 acre of land and cast 1 vote for every acre owned. But behind this democratic facade, Disney's rule was absolute. No individual owned 1 or more acres of property within RCID, which meant no one could qualify to sit on RCID's board of supervisors. Indeed, Disney sought to limit residents in the district altogether, turning Epcot into a theme park instead of a residential community, and de-annexing the town of Celebration so the town's inhabitants cannot dilute Disney's control. That was a big part of Celebration, was getting it out, getting it under its own government. Celebration has a CDDA, Community Development District, which is the power that controls Celebration.